Discriminatory. But in 1988, there was a whole lot of stuff that happened. So we actually got, it doesn't happen anymore, I tell you it doesn't happen anymore, we actually got bipartisan support. Both Republicans and Democrats came together for new fair housing provisions. And I'll tell you, the backstory of this, if you're interested, was that at the time, so the two new provisions that were being added were families with children and persons with disabilities. At the time, Ronald Reagan and later George Bush, but Ronald Reagan had a general counsel who had a son who had a mobility disability. And he actually pushed this provision for the Fair Housing Act. Quite amazing. White, not a person of color, but because the disabilities provision was at issue, pushed Ronald Reagan to get behind this law. That's a fact. The families with children provision was actually designed to get at subtle race and color discrimination, because it was well known at the time that people of color, statistically, more likely to rent than whites and for longer periods of time. If you look at the national data, has to do with, pretty clear, with inherited family wealth. If you have statistically less inherited family wealth, it's harder to make that down payment to buy the first home. So you're going to rent for longer. So landlords who simply said, we don't take children, effectively had a subtle way of keeping out people of color. It's just absolutely well known. So this was one of the reasons why this was passed. But Congress could get behind it because who's going to be opposed to laws that help families with children, right? So that was a win-win here. The statute of limitations got expanded for HUD complaints from 6 months to 1 year, and for a private suit in federal court from 1 year to 2 years. That's what it is now. You got 2 years to file in federal court. You got 1 year to file your HUD complaint, and the cap was taken off for punitive damages. No longer capped at $1,000, unlimited. That was big. There also were new government enforcement options. Just very quickly, you had a lot of options with the amendments. Before, you didn't. What was new was, if you file a HUD complaint, you have the choice of letting the process work through HUD, wait for a cause finding. If there's a cause finding, you can then elect to either go to the Department of Justice, and the Department of Justice has to prosecute the case. They have no choice if there's a cause finding. Or, if neither side elects, you can have an ALJ hearing before the HUD ALJ. The HUD ALJ can award compensatory damages, a civil penalty. There's no jury. If DOJ takes it, there's a compensatory damages, a civil penalty, punitives, and the right to a jury trial. But in addition to all that, get this. You can also file in federal court. You don't have to, it's not an either or. You could file your HUD complaint, and you could also file in federal court. Ultimately, before you get to the hearing stage at HUD, you've got to decide what you're going to do. But you could actually go both ways. And no exhaustion requirement. It is not like Title VII, Jack, okay? Not like Title VII, where you've got to file with the EEOC if you want, and wait 6 months, and then get the cause, and then get your right to sue letter from the EEOC. None of that. You go straight to federal court right away. So it's a neat thing about the Fair Housing Act. No exhaustion requirement. A lot of states under this law, Congress said, look, we don't want to clog things up in Washington, so if a state passes a law that's deemed to be a substantial equivalent to the federal law, like you pass a state law that has all of the protections of the federal law, we will then defer our cases. The cases will go to the state. So a HUD complaint gets filed in Washington, gets sent out to the state to deal with. And the routine cases typically got sent to the state to deal with. So it would go into the state administrative process, and the parties could elect to have the Attorney General's office prosecute it if they wanted to, if there was a cause finding. Just the same mirror image to the federal proceeding, but on the state level. But for a lot of the claims that were not routine, zoning issues, fair lending issues, things that are more complicated, HUD said, we'll keep those and we'll deal with them with Washington DOJ, Department of Justice, okay, in Washington, Civil Rights Division. To this day, the Civil Rights Division has a very, very aggressive and terrific group of about 40, 45 lawyers that do fair housing in the housing section of the Civil Rights Division. They work all across the country. They work with fair housing groups. They work with the state AGs, both state AGs, and they work with the U.S. Attorney's offices. So some of you know Judy Levy. Before she became a judge and she was in the U.S. Attorney's office, she took a lot of cases out of Washington that she partnered with folks in Washington on important fair housing cases. Okay. We won't go into 3604. 3604, I've already talked about the reasonable modification accommodations, new construction requirements. And then I've got video. Well, let's move right along. I want to get, and I'm going to go past all of this stuff. We're going to go in this later. This is all theories of discrimination, standing. We'll talk about standing later and potential defendants. One thing I do want to say is, you've already heard me say, lots of different defendants, right? I've told you that advertisers can be sued, newspapers can be sued, insurance companies can be sued, lenders can be sued, landlords can be sued, housing owners can be sued, real estate companies can be sued. How is this possible? It's possible because the Fair Housing Act does not place a limit on who can be a defendant. And again, Jack, I keep coming back to you because you're my Title VII guy. But under Title VII, there's only three types of people who can be defendants. An employer, right? A labor union, or a referral agency, I believe. But you've got to be one of the three. If you're not one of the three, if you're not an employer, not a labor union, you're not a referral agency, you can't be sued. Under the Fair Housing Act, it just says, it shall be unlawful to, ... So over the years, all of these different types of entities have been brought in to be defendants. That's one important thing. And on the flip side of the coin, who can bring a lawsuit? Hugely broad. And we'll get to standing, but the first three cases that made it up to the Supreme Court were on standing and said the following things. First, a bona fide person, of course, someone who's looking for housing, can bring a lawsuit. But in the second case that came up, the court said, even if you live, this is the Traficante case, even if you are white and you live in a complex that is discriminating against other folk of color to get in, you who are white and already living there, guess what? You have standing to sue. Why? Because your right to live, to have the social and economic benefits of an integrated community have been denied. Get that. That's pretty broad. The Supreme Court doesn't do that anymore. Those days are gone. But it's still good law. You're white, you live in a large housing complex, you're happily living there, no one's discriminated against you, but you can bring a lawsuit because there's evidence that the building discriminates against other folk of color. Okay? That's amazing. The third seminal case, the Havens case, said fair housing groups have standing to sue because of diversion to their resources when they test and when they ferret out discrimination. And actually said that testers have standing to sue. Testers, in the lower court case, they said both the white and the African American testers had standing, but the Supreme Court said, no, no, no. It's not the white testers. It's only the African American testers. Why? Because of that provision D that I told you about, the misrepresentation provision. It doesn't say, right, just says if you lie about the availability of housing, right, you're on the hook under the Fair Housing Act. Well, the people who were lied to, think about it, were the minority testers. The white testers were told the truth, so they didn't have a claim. So it's pretty cool how that worked out. So standing is very broad. All right, you've now got the Fair Housing Act in a nutshell. And we'll come back and talk about how to evaluate cases and a little bit about how to investigate them. I want to take you through some of our cases a little bit and give you a flavor for just how exciting this work can be and how important it can be in terms of the types of issues that we deal with and the stage that you can play on with fair housing. So back in 2013, I want to talk to you about a practice called reverse redlining, and I'll explain what that means in a second. This has to do with lending discrimination and very much in how we got to our foreclosure crisis. So Matt, you work on foreclosure, right? So this is directly related to your work. For legal services, it's Danielle, is it? You work at legal services, right? So this also, I'm sure you see a lot of people who deal with this. And also, Stephen, you do bankruptcy, so, and for anybody who lives in Detroit, foreclosure is the thing, so all this is going to be reminiscent. So back in 2008, our office was approached by the city attorney for Baltimore. And what the city attorney said to us was, we are having a crisis here in Baltimore. Our minority communities are being hollowed out because there's just foreclosure after foreclosure after foreclosure that's happening there. At the same time, the mayor of Memphis also approached us the same issue. And when we talked to both the city council and to the mayors of both cities, they said, this seems to us like it's a civil rights issue, because although foreclosures are happening across our city, the problem is so much worse in the minority community, and we want to understand why. Why is this happening? And it's destroying our efforts to both, we have been making progress for years in breaking down the barriers to integration, because we had been able to build some mobility between African American and white communities. But with this foreclosure crisis, all of our work is being destroyed, and it's becoming, of course, more difficult to move between communities, because with the devastation that's happening in Baltimore, you know, street after street after street, looking like, as the city attorney said, we fought World War II here in Baltimore and lost. You know? The ability to build equity in minority communities was being stripped out far faster than in white communities, and was having a devastating resegregative effect in Baltimore and in Memphis. I had been doing work for a long time in lending discrimination, and I had focused on the issue because that's what we focused on at the time in the 90s, on what we called redlining. Not reverse redlining, but redlining. Redlining is the practice of drawing a circle around a neighborhood of color and saying, we don't trust the people in that community to be good, have good credit, so we will not loan there. And literally, the Justice Department brought a case against Chevy Chase Bank in D.C. in 1992, where employees of Chevy Chase Bank in D.C., a big bank in D.C., said, if you live east of Capitol Hill, you are not permitted to make a loan there to their own people. You look at the map, all African American, right? Classic redlining. So it's drawing a circle around an area and saying, we're not going to deliver a good product, a prime loan to that community. Reverse redlining, though, is something that started in the early 2000s. And what happened was that prime loans were available only to people with the best credit. And if you didn't have A credit, you fell off the cliff. You couldn't get a loan at all. So some enterprising folks out in California in particular, including at Countrywide and New Century and other of these mortgage companies that became quite famous quite fast, said, we're going to start something called risk-based pricing, which means that as you move down the credit spectrum and become increased risk, we will charge you more. And therefore, the people who have bad credit but are paying lots more in pricing, very high interest rates, they'll offset the people, you know, their risk will be offset by the price they pay. And if we have folk who pay a little bit more with B+ credit, that'll offset their slightly increased risk. Responsible subprime lending, if done carefully, where you're underwriting to make sure the person can actually pay back and afford, can potentially be workable. But what quickly happened was, because this space there had been a cliff, and there was this big space where no one could get a loan, it became incredibly lucrative because there were so many people who now were jumping to get credit who had never been able to get credit before. So quickly, predatory lenders filled that space. But more important, and so we brought one of the first cases against a predatory lender called Capital City Mortgage back in 2000. Why I tell you this story? Because Cap City said, we're going to take your home from you. That was their goal. They wanted to get people behind. They looked for people who couldn't pay back because they wanted to find people who had a lot of equity in their house, get them behind quickly, build up the late fees, and force them to have to foreclose on their house. They would then take the property and flip it. It was a scheme. They were way out on the spectrum. They were engaged in fraud. We brought a lawsuit against them, and we charged them with not just consumer fraud, but we charged them with violations of the Equal Credit Opportunity Act and the Fair Housing Act, because we said you're targeting black neighborhoods in D.C., and we had very clear evidence that they were doing that. We got a great ruling from the judge at the time who said, we called this reverse redlining. We said this is about drawing a circle around an area that's minority and peddling poison to that community because you want to steal the property. It's the flip of redlining, where you deny good product. Here you send the bad product in. Okay, you with me? All right. The judge said, for the first time ever, 2001, Joyce Hens Green said, this violates the Fair Housing Act, reverse redlining, it is a civil rights violation if you can prove it. So as I watched what was happening from 2001 going up to the foreclosure crisis, I could see that as these, what I thought were responsible lenders like Countrywide moving into the risk-based pricing space, what was happening was they were getting caught up in a hot market frenzy, which went like this. They were making so much money initially as the market was climbing, so price values were growing. That meant my equity in my house, even if I was given a risky loan, was going up. So what Countrywide and others said they could do was, we'll give you what's called a teaser rate loan. We'll keep your interest rate low for the first year or two. After 2 years, you're going to float with the market. You're going to be adjustable rate, which means you're going to get a rate, given your credit, you can't ever afford to pay. But don't worry, because the value of your home is going up so fast that you'll have enough equity that we can refinance you to a lower interest rate loan and keep your interest rate low. Because instead of having no equity in your home, in another couple of years, you'll have 20% equity because the value of your home is going up so fast that your loan compared to the value of the home is shrinking, right? So we'll do this for you. That works if the market rises, but if the market either flattens or crashes, the whole thing is a Ponzi scheme. At the same time, these high interest rates that I told you about as you move down that credit spectrum, that was delivering huge, huge profits for investors on Wall Street. Initially, Lehman Brothers, does that sound familiar? Bear Stearns, Deutsche Bank, all these banks, buying these loans. And what they're doing is they're sending money back to the Countrywides to make the loans. Because Countrywide, when they make the loan, they need more money. Give me more money so I can make the loan. How do they make their money? Countrywide makes the money on fees and points at the time of sale. So depending upon the size of the loan, they take a percentage based on the points or the fee, and then they sell it. So they get rid of the risk to the secondary market, to Lehman Brothers. Lehman Brothers packages that thing up, and they sell it to Wall Street, so you all will invest in it with your pension fund, right? So now we've got these giant, what are called mortgage-backed securities that are made up of billions of dollars of loans. Lots of them are delivering at very high interest rates because they're incredibly risky loans at the lower end of the risk-based price spectrum, mixed with other loans. Okay, now let's get back to the Ponzi scheme. So Countrywide says, give me more money, and the secondary market says, we're happy to because we want you to send us more of these loans because when we sell them on Wall Street, we make money, all right? And this starts to churn faster and faster. What does Countrywide do? Countrywide needs to find people who are going to say yes to their loans quickly because they want the volume of these loans to increase because every additional loan they make, the more money they make. It's now heating up. It's turning into this spinning top. So where do they go? They go to the neighborhoods that have been denied loans historically, the neighborhoods that have been redlined. They go to the minority community because that's where people are going to say yes. Because for years, they've been told by Chevy Chase Bank, you can't get a loan. So they say yes. And now the schemes, the loan products become more and more preposterous. What was called liar loans, no doc loans. Like, don't even show me your W-2 form. Just tell me you make enough money, right? You got the loan. Take more money out of your home, right? Take more than the value of your home. We'll do it. All of this happened. You've all heard it. And then in 2007, what happened? The market first flattened, and then it started to go down. And so all of these teaser rate loans hit, and suddenly within the space, so the loans that made in 2005, and they're up now, with the teaser rate in 2007 and the market crash, the banks say, sorry, can't refinance you, you don't have enough value in your home, so now you're going to float with the market. That means that your interest rate, which had been maybe 5%, 4%, now is going to 9, 10, 11, 12%. Because that's what the market is requiring you to pay for the risk on your loan. Suddenly, your monthly payment goes from $250 a month to $800 a month. You can't pay. Within a short period of time, you're foreclosed on. And that led to this unbelievable crash in 2007, 2008. And ultimately, you're now hearing why it was that Bear Stearns went under, had to get bought. Fed engineered a deal in which they got bought. And then Lehman went under in the fall of 2008. Remember that when Obama was running and the crash happened, the market seized up and we nearly had the world global financial shutdown, all because of this. But let's get back to the fair housing issue. I said, watching this, it is a civil rights issue because these neighborhoods, I believe, were targeted because of the minority folk who live there. So this is a fair housing issue, and the relief shouldn't just be equal between white communities and black communities. I said, we need to focus on where the damage has been. So we started into the case. We filed a case based on statistics, and within a week of the filing of the case in the press conference in Baltimore in January of 2008, Beth Jacobson came forward, who had been the lead subprime agent for Wells Fargo. We sued Wells Fargo, by the way. Wells Fargo in Baltimore, Wells Fargo Memphis. She was the lead subprime agent, came forward, and she said, John, I'm going to tell you, I've quit this company. I worked there for 7 years. I made more money than anybody in the 7 years. I was their #1 national subprime agent. I'm sickened by what happened, but I'm going to tell you, you're absolutely right. And she came forward and gave a declaration in which she said, and then brought forward several other people who also worked there who said that in Baltimore, they specifically targeted African-American zip codes, African-American churches. They assigned their employees based on race. They had a marketing group that was created to target African-American neighborhoods. They referred to people with the N word. They talked about them as ghetto loans. And they had a marketing software. I'm going to see if I included it. I may not include the software. But they had a software that actually, on a drop-down menu, I don't have it in this deck, but I have another, and they produced the document for me, which they had saved. Tony Pashal was the ex-employee, that actually had on the drop-down menu said that you could choose the language that you would use to market, and one of the languages that they had in there was African-American. I kid you not. African-American on the drop-down menu. He was so appalled. He was African-American agent. He was so appalled that he complained about it, and he ultimately got fired. She said the way it worked was that we had this incentive plan that went like this. We had prime agents and we had subprime agents. I was a subprime agent. If a prime agent referred a borrower to me and I could get the person qualified for a subprime loan, that prime agent made more money with the 60% of the commission that he or she got by referring it to me. Because if the prime agent put the person into prime, that agent got 100% of the commission. But if that prime agent sent it to Beth, or me, subprime agent, the subprime agent got 60% commission. The 60% that she got for the subprime loan was way more than the 100% for the prime. So she would send everybody over to subprime, and Beth said it was totally easy to get people into subprime. All we do is, if someone said, do you want my W-2 forms, say, no, don't worry about that. We've got this thing called no-doc loan. Just tell me what your income is. But then what Beth wouldn't say was, as soon as you go to no-doc loan, it's subprime. Interest rate goes up. They would tell people to take more money out of their homes. They would tell them to go with 100% LTV loans. They would put them into the teaser rate loans. They lied about all sorts of stuff that had to do with their provisions and what the rules of the game were. But they did that because they were all making money as fast as possible. We have a video in the office about the Wells Fargo case, and Beth's on the video talking about how she got sent on these getaway weekends because she kept hitting the markers of selling these loans. Got sent to Hawaii, you know, where rock groups would sing for them, you know, lavish dinners. She made, in 2004, she had been a paralegal before she came to Wells Fargo. All she was doing was putting people in subprime loans. In her first year, she made $754,000 in commissions. And she showed me her tax statement for that year. It was unbelievable. We said that the injury to the cities, because we said the cities had standing to sue, and we brought the case for the city. We knew borrowers had been affected, but we knew class actions could be brought, but it was the city that came to us as the client. So we brought the case on behalf of the city, and we said the damage to the city was that the vacancies had required the city to board property, to clean it, to stabilize it, to demolish some properties. There had been police department calls, fire department calls, and there were costs for each of these properties. In addition, we said there had been tax revenue loss because there were studies that showed that for every number of feet you go outside an abandoned property, the value of the neighboring property goes down. So if you've got a foreclosed property on your block, it takes down the value of all the neighboring properties. And studies have been done to say this lowers the revenue that the city can get based on the millage rate and lowers the tax revenue that can be got. So we calculated that for the two cities. This is an example. We went to hearings, and what we were very fortunate was that we got into Baltimore, kept unbelievable records starting in 2003. They had kept in a computer every single time they had gone out to a foreclosed property to deal with it. So this is an example. We got into the records. We were able to lay out 3803 Bonner Road in Baltimore, boarded 8 times, cleaned 7 times. Inspectors and 311 callers had reported, you know, fallen, stealing, squatters, and fire. The total spent since 2007, they had in the records, $2,603. We were able to go through property after property after property. We listed in our complaint close to 500 properties that specifically we identified, and then we did the tax revenue calculation. I think I got one more example of this. This was Edmondson, same thing, boarded 5 times, cleaned 11 times, total spent $2,626 on this property just since 2006. What ended up happening was that, make a very long story short, it was a long litigation that lasted more than 3 years. Wells Fargo fought hard, and they argued that the city did not have standing. And the reason they did that was because they knew that this would open the door to lawsuits by other cities. And in fact, we survived. We initially were told we had to be more specific in our complaint and refile with the judge in Baltimore. Then in 2011, we finally won. The judge wrote a terrific opinion saying that we had standing. Same thing happened in Memphis. We got a good decision in Memphis. And in the meantime, when the evidence, the news stories came out about Beth Jacobson and the others targeting the minority communities, the Justice Department, led by Tom Perez, who's now Secretary of Labor, started an investigation looking at whether Wells Fargo had engaged in discriminatory pricing. And in the spring of 2012, they announced that they not only had the evidence, but that they were engaged in settlement discussions with Wells Fargo over this discriminatory pricing, which had been started by our case. We then joined those negotiations, and there was a all-in settlement for $175 million, with money going to both Baltimore and Memphis, money going to individual borrowers in Baltimore and Memphis, and down payment assistance programs being applied in both cities. Pretty much of a landmark, and of course the discriminatory pricing was totally consistent with what we were saying happened. The fact that the evidence showed that they were charging African Americans more made total sense, because what they were doing is they were putting people who were African American who qualified for prime into subprime loans. So if you think about what Beth was doing, what she was telling us was, she told me, I could go back in the files. She said, if you go to trial, I'll go back in the files and I can tell you each person who I put in a subprime loan who would have qualified for prime. And that translates directly to this lending discrimination, because you're basically charging people more than they should have paid. They would have qualified for less. So if you compare them to a similarly situated white person, they're paying more money. And that is what caused, in the end, put so many people in so many bad situations that caused this disproportionate foreclosure. All right, so what's happened as a result? Lawsuit filed by Atlanta, the counties outside of Atlanta County, and the city of Atlanta against HSBC. Another decision upholding standing there. There have been more suits now that have been filed by Miami and Los Angeles suing Bank of America, Citigroup, and Wells Fargo. Quickly, same concept, but this time a vocational school called Richmond School of Health and Technology. We were approached by students at the Richmond School of Health and Technology. They have programs dealing with practical nursing, medical assistant, surgical technology. And for about a 9-month program, they give you a loan for $10,000 to $28,000. The problem was it's a total sham. It's a private vocational thing. They can't certify you. Their teachers don't show up. They don't have any of the externships they say they're going to have. The thing is a scam. And all they do is get the students behind in their loan payments, which are federal loans. And what happens is they get the students to apply for the federal loans. The money comes to the school from the federal government. They cash the check, right? The student can't ever get a job because this RSHT is a total fraud. And then the students are like the secondary market. So it's like the school's like Wells Fargo. They take the money at the time of closing, and then the risk goes, instead of going to the secondary market, it goes to the student. So the student's stuck. But these debts are not dischargeable in bankruptcy, right, Stephen? So students are in trouble for the rest of their lives, and it's disastrous. But here's where I'm going on it. So we were approached by a number of students, and we were told, same thing as in Wells Fargo. The ex-employees told us that W-2 forms were altered, signatures of students were forged. We had one, and again, on film, we have a video about this, ex-employees telling us about how they watched signatures of students being cut out and pasted on loan forms going to the federal government. Right? This is potentially criminal stuff. Attendance records and grades altered. Why? Because they had to keep the students in the school. If they failed them out, right, they wouldn't, the loans would stop. So they had to keep them in the school. Employment statuses were falsified. All this stuff is going on. And so sham education. Purpose was to milk the government for loans. But Richmond, and now I want to show you this map. This is Richmond, and like Detroit, like Baltimore, like Memphis, heavily segregated. So the green here is African American. The blue is white, right? And you can see this is 1.1 person. These are amazing maps now. The resolution is incredible on these. So you can see how segregated Richmond is. We looked at the campus and we saw that the campus in Richmond, even though Richmond is roughly 34% African American, yeah, the MSA is 30.1% African American. And if you look at folks who are over 25 with a high school diploma, it's 33%. Yet RSHT had a 75% African American student body. I said, that doesn't make sense to me. How can that be the case? Unless they're engaged in reverse redlining. So when we started to talk to the ex-employees about that, they told us, oh yeah, of course we did that. They were like, why didn't you ask? So they used flyers, they went door to door, they advertised on BET, hip-hop stations. They talked about being on the bus line, which was in Richmond, is a euphemism in the minority community. If you're on the bus line, it means the bus, they're talking about a particular bus that historically goes right through the black community. So if you advertise you're on the bus line, it means you have a direct transportation right to the black community. They targeted food stamp recipients, they had open houses, they went to African American schools. They talked about that. One of the one of the administrators, Tiana Branch, said that we targeted schools and we targeted low-income and African-American neighborhoods. That the reps told me that these were the admissions officers folk. They said they could flash their smiles and convince African-American female applicants to agree to take out loans without asking any questions. The reps told me that they knew many of the applicants did not have any idea what they were getting into. And that's exactly what they did. So we brought a reverse redlining case under the Equal Credit Opportunity Act. Because now remember, it's not Fair Housing Act, but it's Equal Credit Opportunity Act, because this is not a loan that's secured by real estate. And the Fair Housing Act covers only loans that are secured by real estate. But ECOA is very similar. We alleged fraud at the for-profit school, but also reverse redlining. And then we ended up settling the case just this past summer for $5 million, 4,000 students will recover out of that $5 million pot. It was class action. The school is a family-owned business, so they hid a lot of their money. So this was a significant bite, but at least students will get now some money back towards their loans that they're in on. But it's another example of this reverse redlining concept coming from fair housing, but applying more broadly to what I'm going to call this problem of structural racism, which I want to end with. The CFPB, which is the Consumer Financial Protection Bureau, watched this lawsuit, talked to us about it, and they now have started to file their first lawsuits against major for-profit vocational schools. ITT Educational Services is the first one they filed where they're alleging fraud, and I hope it will get to reverse redlining. Don't really have time right now to talk about the eminent domain issue, but I will say this just very quickly. The problem has come full circle because the foreclosure crisis now has taken its toll. And now what we have is this problem of banks say, all right, if we can't do subprime loans anymore, then we're going to go back to prime loans. And when you go back to prime loans, what does that mean? Back to redlining. It's just back to redlining. And that's what we're seeing. Credit's drying up in the minority community, but credit is expanding in the white community. So we're now focused in our practice back again on banks that are, we think, denying good credit to African American communities, to Hispanic communities, while increasing it to white communities. But some cities are taking the reins in their hands. Once again, just like Memphis and Baltimore came to me and said, we got a problem, can you do something, can we be the actor? What happened is some enterprising mayors in California, led by the mayor of Richmond, not Virginia, but Richmond, California, saying, look, we want to do this. Richmond is a predominantly minority city. It's a majority minority city. She said, we have all these underwater borrowers there. That means borrowers who at the height of the market took out a loan. Property was supposedly worth $400,000 at the crazy height of the boom. So they got a loan, 100% LTV for $400,000. Well, that property is now worth $200,000. So that borrower has every reason to walk away from that house, right? Because you're paying $2,000, $3,000 a month in just an interest alone on the loan. You could rent the property for $800, $1,000 that you need. You're building no equity in the house. You're just paying interest. So why would you stay in the house? You just walk. And when you walk, the house becomes vacant. And the mayor said, our city's being hollowed out. We got to do something. The investors who hold these loans will not write these loans down. Even though they're never going to get $400,000 back on this property, they won't write down the principal. So if they're not going to do it, why don't we use eminent domain authority and seize not the house, but the loan for fair market value? So they said, eminent domain is where you take property to build a bridge or to expand a highway. The state has authority to do that, or a city has authority. Look, why can't we use eminent domain authority and we'll say, investor, you hold this loan for $400,000, we'll offer you the fair market value of that property, which is $200,000 for it. We'll offer you $200,000. If you don't take it, we're going to take it from you. We'll take it from you, right? And we will pay you that fair market value. You just won't have a choice in it. But we're going to, just like when we take the property to build the highway and give you the fair market value, we'll give you the fair market value. It's $200,000. And then they did a deal where they said they worked with an enterprising private investment firm that worked with a professor at Cornell to work out this whole plan, where the private investor said, we will take that $200,000 loan and we will refinance it on the secondary market. So actually what they would do is they would say, the property is worth $200,000. The loan should really be 80% of the value of the property, so we'll give you $160,000 for that $200,000 property. They then take that loan and they refinance it on the secondary market for about $190,000, which they can do if they do it through FHA and possibly through Fannie Mae. And then that $30,000 difference, some of it pays the fees of the private investors who are doing this deal. Some of it goes to the city for costs. And at the end of the day, the city has its costs covered. The investors paid $160,000. The investors get a fee for their service, and the homeowner now has a loan for $195,000 instead of $400,000 on the property. So they've got $5,000 equity, a much lower interest payment, and they have an incentive to stay in the house. Everybody wins. So immediately lawsuits started. The banking industry went berserk, saying, how dare you touch the free market? This will never happen. They got the biggest firms in California to threaten the city of Richmond with lawsuits. Jerry Brown, the governor, weighed in and said, keep your hands, Wall Street, off of our mayors, right? This is their right to do this. The Attorney General of the state of California weighed in, said the same thing, and said, in fact, if you try and regulate the market, because what the industry said was, we're going to retaliate. They literally said that. They said, if you do this, City of Richmond, we will change the rules so any property that's located in the city of Richmond, California, if anybody wants to make a loan on that property, they will be banned from the good secondary market, from the Fannie Mae, Freddie Mac secondary market. This was SIFMA, the Securities Industry Financial Management Association. These are the big boys who run the whole, it's like NASDAQ. They run the secondary market. They said, we're going to change the rules, and we will punish you this way. And property values will drop, and you will have a calamitous effect. And so the Attorney General of the state of California said, you do that, we're going to sue you for antitrust violations. The City of Richmond came to us and said, is this a fair housing violation? I said, yes, this is redlining. This is the industry redlining the city of Richmond, right? Drawing a circle around saying, any loan that comes from the city of Richmond, because you're exercising this right, you can't get into the secondary market. That means, even if you're not in the eminent domain program, so it's Dave. So you say you want to buy in city of Richmond, even though you're not in the eminent domain program. You couldn't get into the secondary market to get a Fannie Mae loan. So if you went to a bank, you went to Bank of America, they'd say, Dave, you want to buy in city of Richmond? We can give you a subprime loan. Can't give you a prime loan because we can't sell it to Fannie Mae under the rules of the game because you're from Richmond, California. So you're not going to move to Richmond, right? So we said, you do that, we're going to sue you for fair housing violations. So all came together in court in this past fall in front of a district court judge by the name of Breyer, who is the brother of Justice Breyer on the Supreme Court. And he said, because Richmond had technically not pulled the trigger on the plan yet, he said it's premature. Come back to me when you pull the trigger and when they retaliate. So we're all sitting there. Everybody's got the gun loaded and pointed at each other. We've said, we're suing you, you do that. They're saying, you pull the trigger on the eminent domain program, we're suing you, right? We're all looking like this, and this is the next big battle. And every city, not every city, but a lot of cities around the country are watching this to see what happens, because eminent domain could be a way to deal with this foreclosure crisis. Could be a way for the city of Detroit to deal with this problem. If the city of Detroit could actually take properties for their true fair market value, right, and get a lot of these loans written off. So again, this problem, if this is the fair housing issue that I'm talking about. So we're coming, as I say, full circle. We started with redlining, we went to reverse redlining, and now we're back at redlining. I want to end last couple of minutes with what ties, I think, fair housing cases together right now, big picture. I want to get you excited about how important this work is before we get into the nitty-gritty of the nuts and bolts about how we do the cases. This gets to the heart of what I call structural racism. What is structural racism? I call it a practice that exploits historic discrimination and spatial segregation for private or political gain. Think of Wells Fargo. Wells Fargo takes advantage of the fact that we have historically segregated black and white communities with one community that's been denied good credit for years. And they take advantage of that to exploit that to make money. They know they can take their bad products to that community, make money fast, and that's exactly what they did. And whether they intended to do it, as Beth Jacobson says they did, or whether they just did it because they say that's where the need was for the products, right? That would be the disparate impact theory. That would be the market took you there, but the result was the minority community got hollowed out disproportionately to the white community. Sometimes we see governments taking advantage of spatially segregated and historically discriminated communities because there's no political power in those communities to fight back. So they can destroy neighborhoods, they can engage in rehabilitation plans or redevelopment plans in minority communities because there's no political power to oppose it there. That's a type of structural racism. Why? Why? The why is easy. It's because profits and power can be extracted more easily from underserved communities that have been made vulnerable by decades of historic discrimination and segregation. It's vulnerability. And what that means is that if we do not attack these practices, and if we don't have the ability to attack these practices of structural racism, we are going to have equity stripping writ large on minority communities, which is exactly what Wells Fargo did. It's exactly what RSHT did. RSHT, by putting disproportionate numbers of minority students into these terrible loans that they can never pay back because they can't ever get a job from the sham education, is setting them back. It's a type of equity stripping. It's taking away your future, as it were. It's ripping out what you have to live on and build from, whether it's a home or whether it is putting you behind in a loan so you can't get a job. This is, if we have this equity stripping, we are building the barriers to integration higher. We are forcing resegregation. We are moving backwards, not forwards, and we are increasing economic inequality in America. Not just between the very rich and the very poor, but between people of color, between black folk and white folk, between Hispanic folk and white folk. We are building a racial divide and we're building an economic divide because the two of them go together. Always have, and always have because of historic discrimination and segregation. That's why structural racism and the Fair Housing Act's ability to attack it by looking at lending discrimination, housing discrimination, and focus on disparate impact is so incredibly key. These are the harms. Strips the equity out, and it creates new barriers, and it perpetuates segregation. And this is where I would say, let's get back to the very first thing we talked about this morning, right? The integration versus non-discrimination debate. Conservatives don't worry about this. The conservatives say, as long as there's no discrimination and everybody's equal opportunity, let's not worry about where people live. But folks who care about disparate impact say, no, where you live really matters, because if we are a segregated society, it creates the opportunities to equity strip, to exploit the way I've described, and to increase economic inequality. But again, let's go back full circle. I don't mean to get political here, but the conservatives are not that concerned about economic inequality, because for them it is a laissez-faire Adam Smith world where it's the survival of the fittest. But for people who believe in the need to have a middle class and economic equality for a society to survive, it's everything, whether we have segregation or not. It's everything. And that's why the stakes are so high right now. They are incredibly high. The Supreme Court is really looking, it's tried twice now, to take away disparate impact. Both cases got settled, the Magner case and the Mount Holly case, just this last year. They're looking for another one because 5 votes on the court want to take away disparate impact, just like what they're doing with campaign finance reform, just like what they did with class actions with Walmart. They're looking to do this because they know exactly where it's going to take the legal and public policy and social economics world. I won't talk about ex-offenders, but I'm going to run right through this because I want to get to some maps. But if you think about the ex-offender issue, I'll just quickly say it's the same structural racism question. We have a prison population in America that is 85% African American or Hispanic male. Let me repeat that. 85% African American, Hispanic, or male. Nearly 3 million people are in prison or jail right now in America. That community got that way, Michelle Alexander argues in her book, The New Jim Crow, because of discriminatory policing practices in the 80s and 90s that she argues were literally designed to target the minority community, to take minority folk off the street with these incredibly harsh 3 strikes laws and drug laws. However it got that way, though, the result is clear. We have a highly segregated prison population. For folks who want to come out of that community and who earn the right to come out and back into society because they've served their time, when they re-enter society, they can't get a job for the most part because there are bans on ex-offenders from taking jobs, which the EOC has now said you can't do. There are bans on voting if you have a felony conviction in many states. And most importantly, there are bans on housing. So a lot of private landlords, believe it or not, have blanket bans on if you have a record, you're done. You cannot get housing. This has a huge disproportionate impact, and we're in the process of looking at this issue very, very closely because my position is it violates the Fair Housing Act to have a blanket ban. Why? Neutral rule or practice. We just say, we don't care if you're white or black. If you have a record, can't live here. Simple neutral rule. I say, fine, you don't have an intent. I would argue you probably do have intent. You know exactly what you're doing. You're changing the color mix of the building. But let's set that aside. Let's just say no intent. The impact is clear. People coming out of prison are overwhelmingly black and Hispanic. So now the question is there a less discriminatory alternative? Landlord says, I need to do it because I'm worried about the safety and health of other tenants. I say, you can achieve that goal with a less discriminatory alternative. How do you do that? Get rid of the blanket ban, evaluate everybody on an individual basis. What's the nature of the crime? How long ago? What's the evidence of rehabilitation? I would argue someone who went in for marijuana possession on a 3 strikes and has done their time is a whole lot different than a sex offender, right? Or someone who's in for first-degree murder, or whatever it may be. But every individual is different. You've got to give everybody a chance. That's exactly what the EOC has just said in new regulations. Employers cannot, it's called ban the box. You cannot just have someone check the box that says, I have a record, and you don't get a job. EOC says you've got to evaluate everybody's fitness for the job based upon who they are, the nature of whatever crime it was that they were in for, and how long they've been out, the evidence of rehabilitation, and their skills. Okay. I'm not saying that's going to eliminate discrimination. I'm just saying it's going to move the dial a long way, right, to give people a chance. Why does it matter so much? It matters because the data shows that if you cannot have stable housing for every move that you make in the first year out of jail or prison, the chance of recidivism goes up 25%. So if you have no stable housing, you typically go back to the neighborhood where you were from, right? You're dependent on people to give you housing, and you are right back in many times where you were. You don't have a chance with your family to get reconnected with your family, get that job, and build that new community that you need. It's really vital. That's another example of structural racism, right? Perpetuates segregation. It strips equity because it puts people right back into prison, essentially, but gives people no chance. It's all part of the same theme, but the Fair Housing Act has the ability to address these issues. Do you get how powerful this law is? It's really big. And that's why it's amazing that it survived this time, and it's clear why the thinking members of the conservative faction of the Supreme Court want to do what they can now to try and target it, to limit it. But we got to fight that, and we got to use it now with fair housing groups to build our cases. I want to end with showing you some of these maps. If you thought that segregation was only in Detroit, think again. Again, white is blue, green, African American, the orangey is Hispanic. It's in all parts of the country. This is Birmingham, Alabama with these maps, 1.1 person. St. Louis, Missouri. Amazing, huh? In the Midwest. Philadelphia, Pennsylvania. I mean, look at Philadelphia. I mean, this is quite amazing. I mean, if you look, if you know Philadelphia, for those of you who know Philadelphia, this is West Philly, this is North Philadelphia, right? Highly segregated. Atlanta. African American in the north, white. That's where the lawsuit's been brought against HSBC. And of course, Detroit. That map is stunning. And I have to tell you, I mean, you know what this is? This is 8 Mile Road right here. Yeah, that's 8 Mile Road. Okay. I always end my presentations about structural racism to audiences around the country who don't know Detroit, maybe never been to Detroit. I always end with this map, and it's just like gasps. You know, people go, "Can this be America? You know, can this be America?" People say, you know, integration's not a problem. We live, you know, civil rights. How many people have told you the civil rights movement is a thing of the past, right? Look at this map and tell me the civil rights movement is a thing of the past.